1.
We'll hear argument in 22-420 in the interest of J.S. from Kaufman County and the Fifth Court of Appeals District. Petitioner is represented by Mr. Cody Rutowski and respondent by Ms. Tina Montoya. Mr. Rutowski, we'll begin with you.
Thank you, Chief Justice Hecht, and may it please the court. The Court of Appeals erred by vacating the trial court's judgment under Section 263.401 of the Family Code for two main reasons. First, although the trial court did not expressly make an extraordinary circumstances finding on the initial automatic dismissal date, such a finding is implied here and amply supported by the record. Second, subsection B's findings are only mandatory, not jurisdictional, and mother and father expressly waived any complaints they may have about the trial court's compliance with subsection B. This court should reverse and remand to the Court of Appeals to consider in the first instance the issues mother actually raised in her appellate briefs to that court. Turning to the first issue, this court in In re GXH held that the subsection B findings could be implied in that case, and this court's reasoning extends to this case. In GXH, this court relied upon cases recognizing the general rule that in the absence of written findings of fact and conclusions of law, all findings necessary to support a trial court's rulings and judgment are implied if they are supported by the record. Now, the legislature knows how to create exceptions to that general rule, and it has done so.
And here the legislature has said pretty clearly trial courts are supposed to make these findings. So why shouldn't we respect that?
Well, yes, Your Honor. So there's several places in which the trial courts are required to make certain findings. That's pretty commonplace, but this court implies those findings anyway. I mean, that is, of course, the nature of the implied findings.
But have we ever done that where the legislature has amended a statute to say, no, really, we mean that you're supposed to make these findings?
Respectfully, Your Honor, I don't see where the legislature here amended the statute to say that these findings were specifically necessary to be made orally or in the record. Now, the legislature has in other provisions of the Family Code required that findings be made expressly, be made in writing, be included in an order. Examples of that are cited on pages 15 to 16 of our opening merits brief. There's no such language here in subsection B or in any part of this statute. So thus the general rule of that implied findings, the general rule allowing implied findings to support a trial court's judgment applies here.
Well, that's not really what we said in GXH, though. There was a hearing and there was no record of the hearing. And so we presumed that the finding was made orally in the record at the hearing. We didn't imply that a finding was made when there was an indication that there had been no finding, right?
So what this court did in GXH is it relied on two cases, Marchand, I believe Bradbury, and those are both cases in which the record was available, and those are cases in which the trial court held that a finding could be implied if it was supported by the record. And indeed, Chief Justice Hecht, and then Justice Hecht noted in his dissent in re-DFPS that these findings could be implied. And there's been no relevant change to the statutory language of subsection B that has made these findings, that has added a requirement that the subsection B findings be made expressly on the record or included in any order. So thus, again, this court in GXH addressed the narrow issue and the narrow circumstance that was presented before it and didn't necessarily go any farther. But its reasoning extends to a situation such as this, in which the finding may not have been made expressly, but is sufficiently supported by what happened, sufficiently supported by the record here. And again, those circumstances here are mother and father's last minute request for a jury trial, the trial court's decision to grant that request, the trial court's inability to hold a jury trial before the initial automatic dismissal date, something that would have been difficult to do even under normal circumstances, given the timing of the request, and all the more difficult given the still lingering effects of the global COVID-19 pandemic. And then mother also highlights an additional extraordinary circumstance in her response brief on the merits, and that's the absence from the attorney ad litem at the proceedings on the initial automatic dismissal date. Now, that was scheduled to be a Zoom trial, a final bench trial on the merits. And again, there's no indication for why the attorney ad litem is not present here. Now, those circumstances have been held by courts of appeals for many years, and certainly predating the several amendments of Section 263.401. to be sufficiently extraordinary. So we've got the TTF case in 2010, in which the court held that a trial court's inability to hold a jury trial before the initial automatic dismissal date was sufficiently extraordinary under subsection B.
Sir, let me ask you, if you do not prevail, what's going to happen to this child?
So my understanding, if I do not prevail on either of the grounds here, then yes, the department's temporary managing conservatorship over the child would terminate. The department would still have the ability to file a new position, but it would have to start the proceedings all over again. Now, there is evidence.
So my understanding is that when the child was removed, the child had methamphetamine levels of more than 13 times the amount needed for a positive result. Would that evidence still be at play in a new removal?
So I think that's somewhat unclear. I'm not sure the court has actually reached that issue. Seems like it could be, and it seems like there's certainly been circumstances since then that would justify another removal. Now, I will say that I believe Mother has supplied evidence in the record here that the foster parents with which the child has been placed for, I guess, the last almost 2 years now, have filed a petition to terminate parental rights here. That, as I understand it, is currently been stayed pending the result of this proceeding here. Point being that there are other options for the department to continue to provide for the best interest of the child in this situation, even if we don't prevail here. Now,
do we need to agree with your position that an express finding is not required in order for you to win?
No, not necessarily, Your Honor.
So if we were to hold that an express finding is required, what's your fallback position?
The fallback position here would be that the subsection B findings are only mandatory and not jurisdictional. And again, that is supported both by this court's interpretation of subsection B and in re DFPS. There's been no relevant change to the language of subsection B to make that to make subsection B's findings jurisdictional. That's in contrast to the original version of subsection B as it was enacted in 1997. There, the legislature expressly included jurisdictional consequences. Specifically, the finding required in subsection B in 1997 was necessary in order for the court to extend its jurisdiction. The court replaced that language in 2001 and deleting the jurisdictional component, and instead said that the finding was necessary in order for the trial court to retain this case on its docket. That is certainly the deletion of jurisdictional language is a clear indication that the legislature has intended to remove the jurisdictional effect of subsection B. And despite amending the statute several times since this court's decision in re DFPS, including in each of the last 4 regular sessions, the legislature has not added jurisdictional language into subsection B.
So if it's mandatory rather than jurisdictional, I take it your position is that any missing finding that was expressly required to be made was made later by the trial court, so that cures the problem.
So that would be one potential reading of it. One way to rule for us. Another would be that any complaint about a failure to make that finding is subject to waiver, and here Mother and Father expressly waived on, I believe, page 11 of the supplemental recorder's record, expressly waived any complaint about the trial court's order retaining the suit on its docket and extending the initial automatic dismissal date. So this issue was expressly waived and thus would not properly be before this court. And again, a mandatory reading here is consistent with the purposes of the statute here, which is prompt and final resolution of the statute. And again, this court said in DFPS that it would be unreasonable to allow a jurisdictional reading that would undo, which in this case is a jury trial on the merits here, terminating parental rights years afterwards because the trial court did not say some magic words. And again, comparing the consequences of the jurisdictional reading to the consequences of the mandatory reading further supports a mandatory reading here. Again, jurisdictional reading leads to potentially the result here where we get all the way to a jury trial only to have that vacated. And here we are almost, I believe, 3 years after this case was initially filed. Still, the child is in legal limbo. And as I discussed with Justice Lehrman, that would only continue if the department does not prevail today. Now, Contrast that with the consequences of the mandatory reading. Then that would actually incentivize prompt and final resolution of the case, because any complaints with a department's subsection D findings or its orders retaining a suit on its docket or extending the automatic dismissal date would have to be raised timely and preserved if necessary for review on appeal, and potentially could be raised in a mandamus proceeding, all of which would allow the trial court, give the trial court the opportunity to address this in the first instance and thus resolve this issue, in this case, 2 years ago instead of now before the Texas Supreme Court. So all of those readings, and again, this court, when it's trying to determine whether statutory requirement is jurisdictional or mandatory, it places a thumb on the scale of a mandatory in favor of a mandatory reading. Indeed, in just last year in SCVMB, this court described the presumption that is statutory, said that there's a presumption that a statutory requirement is only mandatory, not jurisdictional, and that presumption can really only be overcome by a clear statement of legislative intent to the contrary, something that this court described as a clear statement rule. And here, there's no such clear statement in the language of subsection B for the reasons I've already discussed with that language here. Turning back to the implied circumstances finding, I believe I covered what I believe would be the extraordinary circumstances necessary there. I'm happy to answer any further questions on whether these circumstances are sufficiently extraordinary. And again, to be clear,
should the inquiry about whether the circumstances are extraordinary focus on information that was available at the time the extension was made?
That certainly would, yes, that would seem to comport with it because, or certainly before, yes, at the time that the extension was made and before the automatic dismissal date, because that would have to, I mean, would be what was necessary to support the finding itself. Yes, Your Honor, I agree with that. There's any other questions on the extraordinary, on whether this can be implied here? I'm happy to address those. If there are any other questions on the extraordinary circumstances finding, beyond that, I am happy to reserve any further argument for my rebuttal.
Any other questions? Thank you, Mr. Rutowski. Ms. Montoya, we'll hear from you.
Thank you, Mr. Chief Justice. May it please the court. I would like to start today with addressing the issue of jurisdiction, unless the court has a preference on how I address the issues, or if the court has questions before I get started.
I think you can go ahead.
Thank you. In GXH, I agree with Justice Busby that the court did find that subsection B, the first sentence in subsection B, the extraordinary circumstances, I believe that was considered jurisdictional because of the way that the opinion read, how the court differentiated the first sentence in subsection B from the second sentence in subsection B. I know the court was specific in not stating that the subsection A was not subject matter jurisdiction. It just stated jurisdictional. I do believe that it would be, in the legislature intended it to be subject matter jurisdiction because, as we know, subject matter jurisdiction cannot be conferred or taken away by consent or waiver. And also
in GXH, we said, while a trial court's failure to timely extend the automatic dismissal date before that date passes is jurisdictional, claim defects relating to the other requirements of 263-401B are not. So why aren't the two findings other types of claim defects that fall within the non-jurisdictional realm there?
I'm sorry, why, could you repeat that last part? Why are they?
Sure. So we said what we said in GXH is what's jurisdictional is the failure to timely extend the automatic dismissal date before that date passes. And I think everybody agrees that happened here. The trial court did extend the date. The question is, did it make all the findings it needed to support that extension, right?
Correct.
Okay. So if we've got what GXH said was jurisdictional, the extension of the automatic dismissal date before that date passes, then why isn't everything else mandatory but not jurisdictional?
I believe it's not mandatory because you have to make the findings in order to do the extension. And then if you look at the history of the statute and how it's
Well,
been,
I certainly agree that that's what the statute says. We might say that that's mandatory, but why should it have the further consequence that those predicate findings are themselves jurisdictional?
I think because of the history of how the statute has been changed. Years ago, I don't recall the date, when they removed the legislature removed the requirement to file a motion to dismiss, and they included the jurisdictional wording in this. And I believe it was so that the parents did not have to preserve that complaint at the trial court. And I think it was meant to automatically terminate if the findings weren't properly made, because otherwise judges can just extend by signing an order. There's case law right now that says there's no motions required to find extraordinary circumstances. Hearings not required. Obviously, written findings. We're here today to determine if that's the case. If the court does not require evidence to support the findings, which kind of goes to my argument of the petitioner argues that the court can do implied findings, and that should be sufficient enough. But if they do that, then pretty much the court can just sign and not put anything on the record.
Well, those seem like two different questions, though. One question is, does the court have to make the findings or not expressly? And then it seems like it's a separate question. And does that have to be supported by evidence that was available at the time of the extension? Seems like one question. And then it seems like it's a separate question about whether the failure to make those predicate findings is jurisdictional or not.
I think they're tied together, Justice Busby. Obviously, the court will make that decision today, but I believe that going to the issue of making the actual finding, the extraordinary circumstances, I believe there are many cases out there talking about whether or not extraordinary circumstances, the court made that finding. There are many reasons out there for that. Petitioner addressed and stated that there's a case out there where the jury trial request was allowed to be an extraordinary circumstance. I would argue, Your Honor, that the sentence actually says the court finds the the statute subsection B, the court, unless the court finds that extraordinary circumstances necessitate, which also means requires, the child remaining in the temporary managing conservatorship of the department. I believe that the focus of whether or not there are extraordinary circumstances should focus on the child, not the parents wanting a jury trial at the last minute. I also believe that in my bench exhibits that I filed with the court, you'll see exhibit 1 is the full transcript. And when you read that transcript, there is no testimony that was taken. There was no, I can't find any evidence in there that could even be implied if the court decided to make that ruling today.
If the requirement to find extraordinary circumstances is mandatory and not jurisdictional, as has been postulated, how is it enforced? What is the consequence for not complying with it if it isn't jurisdictional?
I think that cases will just go back to how things were before the statute was amended. And I think cases will just be extended just as they were before if there's not a dire consequence of the department being required to watch their deadlines and to make sure that orders are signed timely, or to make sure that they request the specific relief necessary, as opposed to, in this case, the trial department's trial attorney only requested that the court find that it's in the best interest. If the trial attorney had asked that the court find that there's extraordinary circumstances and in the best interest, we wouldn't be here today.
Well, let's say it's just they extend the deadline. They say, I'm extending it under subsection B, and that they don't make any findings at all. And there's no way to imply them, that they clearly forego the findings. Is there recourse for you if the consequences are not jurisdictional?
There is no recourse. I don't believe. I just believe.
Could you argue that that the case should be dismissed because it cannot be retained on the docket? And that's not necessarily jurisdictional, but that's a grounds for dismissal on the merits. I'm just wondering. I really don't know.
I don't believe.
Mandatory. It seems like you would be able to do that, right? To say
sorry.
you didn't make if it's mandatory that you make the required findings, wouldn't you be able to object and say, well, you didn't make the findings, so the case should be dismissed?
Yes, but that would go back to, that would have to be done in the trial court, correct? They would have to, and that's petition.
I don't know. You tell us, but.
Well, yes, Your Honor. I think that's exactly what would happen. The petitioner argues that the mother waived that argument because she didn't bring it up in the trial court. And that kind of brings us full circle to, okay, now the parents' attorneys have to be cognizant of, oh, today's, the dismissal date, and we should have asked for the case to be dismissed instead of asking for a jury trial, or just agreeing to extend the case. When I read the transcript, what happened that day is they went in chambers and then they came out and the trial judge ordered mediation. I believe under those circumstances that it was an agreement to extend, to go to mediation and see if the case could get settled. Prior to the jurisdictional aspect being included in subsection A, cases were going on for years. And I'm not saying that it's just the department. I think the parents' attorneys were agreeing. Everybody was agreeing. Let's just extend. Let's just extend. And children were being, were kept in limbo. And I think that was.
I think that what we are trying to get at, though, is that there has to be a place in between. Even if we call it jurisdictional, there's a big difference. There's a trend going away from calling things subject matter jurisdiction, because when something is subject matter jurisdiction, as we all know, there are huge ramifications of that. Any judgment is void. You can bring it up anytime. There's just lots of things that are serious consequences, but you can call something. There's other types of jurisdiction other than personal jurisdictions that are being recognized, including in the restatement of the law. And so why couldn't the court dismiss the case if in fact what was required wasn't done, without having these huge ramifications that could be associated with calling something subject matter jurisdiction?
Well, if I could address the dire consequences issue, Justice Lerman, Texas Family Code 161.211 states that a direct attack on a termination order can only be done in 6 months. So even if the court decided to call it subject matter jurisdiction and it was a dire consequence, regardless, this statute says you can't go years later. You can only challenge that termination order for 6 months.
I don't think that's true. If it were subject matter jurisdiction, it would be void. I mean, a statute's not going to trump that, a finding of subject matter, or certainly arguably. And so therein is the problem, it seems to me.
Okay, so if we didn't call it subject matter jurisdiction, but it still could be dismissed,
Right.
We still do have, that's the statute that says you cannot challenge a termination order for 6 months. You have the adoption statute that also says Texas Family Code 162.012 that adoption cannot be collaterally attacked for 6 months. You had asked earlier, Justice Lerman, regarding what would happen to the child in this case. And yes, the foster parents did file an emergency order seeking a private termination. And when the Fifth Court of Appeals made their ruling, there's other remedies as well. The caretakers could file a original suit under 102.00312. And so regardless what the court calls it, if it's just personal jurisdiction, which sounds like, actually, now that I'm hearing you say that, it sounds probably like a better idea. But I don't think the dire consequences are what the petitioner had originally set out to say. I think there are options.
Do we need to decide in this case whether what would happen if it, say, assume for the sake of this argument that that we say that the predicate findings are mandatory, but they're not matters of subject matter jurisdiction? And do we need to decide if the parents have to object in the trial court or if they can raise that on appeal? In this case, when the trial court later went back and actually made the express findings in the trial court, do we need to decide what would happen if the trial court had not done that?
Absolutely, Your Honor.
Why, if it's not presented here?
I'm
So
sorry.
I think we're talking about a case like what happens if you don't make the predicate findings at all at any stage in the trial court, and then it comes up on appeal and the parents say, well, those were mandatory and you should have dismissed. That's not the case we have here, right? Because the trial court did make the findings. It just made them after the extension.
Well, I would disagree that it made the findings because it didn't make the extraordinary circumstances findings. It only made the best interest finding.
At the time of the extension.
Correct.
But it did make both findings later.
I'm sorry, I don't. Oh, you're talking about when she entered the order?
Yes.
Okay, after the dismissal, after the dismissal date. Okay, yes.
Is that not correct, or am I misremembering?
That is correct. I apologize. Yes.
Okay.
And so
what effect does that have, if any?
That
if the requirement of the predicate findings is mandatory but not jurisdictional, does that cure any error if the trial court comes back later and makes the findings expressly?
I don't know. I apologize. I just don't know.
That's a fair answer.
The court has blown past a prohibition on retaining the suit on its docket at that point, and
I'm sorry, could you say that one more time?
I would think that at that point, the court has blown past a prohibition on retaining the suit on its docket, and it can't retroactively cure its failure to make the appropriate findings at the appropriate time.
That would be my argument. I think that has been my argument. Yes, Justice Blaylock.
Mr. Rukowski was asked if the department loses here, what would it do? And he said, well, they could choose to refile. And the question was asked, could it use the evidence that was available before this termination? And he was unsure. What's your view of that?
No, I apologize. I'm trying to decide what I can tell the court because that did happen when the Fifth Court of Appeals vacated. And the statute is pretty clear that you have to have new facts. So I think, and the trial judge did deny their petition again. And so I do believe that the department would not have any facts. Is it possible maybe they could talk with the foster parents and try to come up with facts? We assume that a child's doing well with the foster parents. So I don't think that the department would be able to. I don't. Petitioner argues that the extraordinary circumstances, he gives the definition in his brief, and part of that definition is extraordinary circumstances is something that's not foreseeable. In this case, a jury trial request is foreseeable. It should have been done. It should have been done 45 days before. I'm sorry. Am I having feedback somehow?
We can hear you.
Okay. So I don't think the court should use the jury trial as a means for saying that the court found extraordinary circumstances, because that was foreseeable. Again, there wasn't even a written jury demand on file with the court. If the court holds today that a jury trial is extraordinary circumstances, I think that the consequences of that is we're going to be right back to where we were before the jurisdictional aspect came in. We're going to have cases just automatically extended for 6 months because people can, the parents, the department can show up and say, we'd like to request a jury trial. And I do think that's what happened in this case. They thought it would settle a mediation, and unfortunately it didn't. And as I expressed earlier, I think the extraordinary circumstances should be more focused on the child. If the statute was meant to, not keep the child in limbo and give the child some stability, why are we allowing any extraordinary circumstance the court can find to extend? I think the trial court allowing.
May I ask you a question about your point? I think it's certainly something we need to think about whether extraordinary circumstances need to be focused on the child. But the other part of the standard is best interest, and that is focused on the child. So do we need both inquiries to be focused on the child, or would they then basically become the same inquiry? Can you help me with that?
I don't think I can. I apologize.
Well, I'm not sure I know the answer either, so we'll give it some thought.
I believe the jury trial request and the granting of that jury trial is basically an agreement to extend the case. There was no objection, although the attorney ad litem for the child was not there. None of the lawyers objected to the case being extended. As everyone knows, Texas Family Code 263.402 doesn't allow the parties to agree to extend the cases, and I think that's why the extraordinary circumstances is required. And my justification for that is 263.402. That's the section that had the requirement that the parents filed a motion to dismiss in order to have the case dismissed after the 1 year. I apologize, I'm out of time.
Any other questions? Thank you, Ms. Montoya.
Thank you.
Mr. Rutowski, you have 8 minutes, I think, for rebuttal.
Thank you, Mr. Chief Justice. I want to start by addressing Justice Blacklock's question, and I believe Justice Lerman asked a similar question as to Justice Busby about what exactly the consequence here would be of a mandatory jurisdiction interpretation of the subsection B findings, and I guess what remedy there would be to enforce that. And I do think a motion to dismiss would be an appropriate vehicle here. We would argue that it can be cured, as it was here, by the trial court's March 30th, 2021 order. But I think there's another effect of that March 30th, 2021 order. And I think it's this, that it provides a further indication in support of the trial court having made an implied finding of extraordinary circumstances at the hearing on the initial automatic dismissal date. Now, during that hearing, the trial court expressly covered 4 out of the 5 parts of subsection B. It made a best interest finding expressly. It set a new trial date expressly. It set a new automatic dismissal date expressly, and then it made further orders necessary for the protection of the child. The only part it didn't cover expressly was the extraordinary circumstances finding. And again, my reading of the transcript there is that the extraordinary circumstances were clear to all who were already there. And there was something that the department alluded to in its motion for an extension here. And again, that's the new timeline on the case, the new orders here, trying to set this case for a jury trial after the initial automatic dismissal date. And again, considering this was happening in the context of a global pandemic, indeed, this was supposed to be a final trial on the merits conducted via Zoom, something that you ordinarily would not see and suggests that there is an extraordinary circumstance. Indeed, this court recognized such extraordinary circumstances in its emergency COVID-19 orders at the
I mean,
time.
that's my question is it seems like there hasn't been much said about that, at least during oral argument today, that, what role did that play? That we had, emergency orders in effect that had to do with, what could be in person, what couldn't be in person, what could be done. You have a jury trial, you have other kinds of issues. And so are you arguing, is that other than just the late request on the day for jury trial, your focus is also on these COVID orders?
Yes, that would be another independently sufficient ground here to justify an implied extraordinary circumstances finding. Again, the basis of those orders is necessarily extraordinary circumstances. I don't think there can be a whole lot of room for debate that the COVID-19 global pandemic was an extraordinary circumstance. So that would provide.
It's hard to see when you wouldn't imply the finding in the way that you're approaching this. I mean, GXH, there was nothing. And so it was the burden of the person complaining about the lack of the finding to establish that there wasn't one, and they couldn't because there was no record, as I recall. And here we have something. I mean, the court says why it's doing what it's doing, and the finding isn't there. So what more could you ask for?
Well, so Justice Blacklock, if I'm understanding your question correctly, you're asking me exactly what situation wouldn't be a sufficiently extraordinary circumstance. If this one cuts, then what doesn't?
No. I'm saying about it. I'm asking about implying the finding. If it's not, if you can imply the finding, the extraordinary circumstances finding, when the court explains what it's doing and does not mention anything about extraordinary circumstances, then it seems to me that the requirement is a nullity because you're always going to imply the finding, I suppose, unless the court says affirmatively that there are no extraordinary circumstances and nevertheless grants the extension.
So I guess here
what else could you ask the parent to show other than the court gave reasons and they didn't include one of the required reasons?
Well, so the first thing would be certainly a timely objection to the lack of an extraordinary circumstances finding, and instead of an express waiver of it. Again, the trial court gave the parents the opportunity here to object to the department's request to extend this automatic extend the automatic dismissal date, and to continue to retain this case on its docket. The parents expressly waived any objection they may have had. This isn't just a forfeiture or something where they didn't bring it up. They expressly waived it and said they were okay with this. And again, this is a particular situation where the extraordinary circumstances dominated the entire first part of this hearing here, trying to figure out how we can hold a jury trial and how soon we can do that. And again, this is a situation where we're trying to interpret this statute in a way that protects the parents. And here it's protecting their fundamental liberty interest in a jury trial, something that this court should certainly said is of fundamental importance, especially in this context. Again, there are certainly situations in which an extraordinary circumstances finding could not be implied. Say there's no hearing whatsoever, there's no motion, there's nothing, there's just a docket entry that shows up. Potentially that could be a situation that just says extension granted. Potentially there could be a lack of extraordinary circumstances. Or if there's just absolutely no indication of something other than the usual. Now, the word extraordinary itself does not necessarily impose a high bar, as the definitions we cited and courts of appeals have cited. Simply so it's something that's outside of the normal here. And
what's the best case we should look to for a definition of what constitutes extraordinary circumstances and what doesn't?
So I guess there are several different cases. I believe there's one cited in our reply brief that cites Webster's third. Unfortunately, the name is not coming to me. But again, the way this court generally interprets undefined terms is by reference to their common ordinary meaning, and it looks to.
But we need to do it in the context of this type of termination proceeding as well. So I mean, Webster's is helpful as far as it goes, but it doesn't have anything to do with parental termination.
Certainly, and there are some cases in which courts have held that issues that were perhaps fully internal to the parents, such as incarceration or failure to comply with court-ordered services, would not necessarily be extraordinary circumstances. And again, what we're asking for here is generally to largely leave this within the discretion of the trial courts, who will be able to suss out and best determine whether there are truly extraordinary circumstances here, whether the parties are acting in good faith, and even say, take a case like this, if there's any question whether a late jury demand was nothing more than a stall tactic, that's something a trial court is going to be in a much better position to judge than we could be on a cold record here, having
It
dealt with
seems
these
like the
parties.
legislature did not want to leave this to trial court discretion.
Well, certainly it gives the trial court the discretion to make these findings, which lower courts of appeal or the other courts of appeals have reviewed for an abuse of discretion, as they would any normal motion for a continuance here. And again, I think what we're asking here is that these circumstances could be considered sufficiently extraordinary, not that they are de facto. If the trial court decides otherwise, then that would still be within the discretion of the trial court. I believe there are no further questions. My time is about to expire. We would ask this court to reverse and remand to the Court of Appeals.
Any other questions? Thank you, counsel. Justice Boyd could not be present this morning, but expects to participate in the decision of the case. The case is submitted and the court will take a brief recess.